Some people just have no business serving on juries. At the same time, there are certain juries that you have no business serving on. As a trial lawyer, it's my job to find out whether or not potential jurors are a good fit for the case that I'm going to present to them and ask a verdict for. We call that voir dire. Voir dire is the questioning of the venire panel, potential jurors, that lets us identify outlooks, life experiences, or firm beliefs that could prevent someone from judging a case impartially. That's because the foundation of every verdict is laid during voir dire. I remember this one trial. It was a traffic ticket trial that we were trying to a jury. Yes, in Texas, you can have a jury trial for a traffic ticket. This case came down to the word of the police officer against the word of my client. You see, I had evidence that the police officer had falsified his report, but I was worried that the jurors would side with the officer even if I presented them with this very clear evidence. So, during voir dire, I asked a pretty simple question. If the police officer says one thing, but my client says the exact opposite, are there any of you who are more likely to believe the police officer because he is a police officer? Nearly the entire panel raised their hands. I went one by one with a follow-up question. Is it fair to say that you'd start the police officer ahead of my client when determining credibility? When I pointed out to them that their answers meant that they might be a little biased in favor of the police for the case, most of them actually agreed. So, after I was finished, I turned to the judge and asked that all of those jurors be stricken for cause on the basis of bias. It goes without saying that if a biased juror is allowed to decide the case, then that would violate my client's rights. Well, the judge agreed, and all of them were kicked off. We're talking dozens of people being suddenly excused. Then, when the dust settled, we didn't have enough jurors to even conduct the trial. This is known as busting the panel. The judge declared a mistrial, so we went home. And then the prosecutor dismissed the case the very next week. I always kick biased jurors off my juries. I represented a father in a trial who is fighting for custody of his children. During voir dire, I asked a pretty simple question. How many of you, by a show of hands, would agree that it is usually in a child's best interest to live with their mother? A couple of jurors raised their hands, so I picked one and asked him if he'd care to elaborate. He then started spilling every thought he had about parenting. He said fathers are the disciplinarians and mothers are the caregivers. He said he thought that fathers ought to be out working and making money while mothers should be staying at home with the children. Oh, he went on and on about how fathers don't know how to take care of young kids or deal with emotional issues. I thought to myself, all right, this one's cooked. Surely he is biased and I can strike him for cause. Well, as soon as I sat down, the mother's attorney got to ask questions. She knew how valuable this juror would be for her side, so she asked him, if the judge told you that you can't consider gender when making your decision in this case, can you follow the law? He said yes, even though he had just spilled his guts about how he thinks fathers have no business being the primary caregiver. He then said that he could ignore his gut and follow the law. Well, the judge thought that this juror's response was just enough to show that he wasn't biased. So the judge denied my strike for cause. However, I still had a secret weapon, my peremptory challenges. With a peremptory challenge, I can kick anyone off the jury without ever having to tell the judge my reason, so long as I don't do it in a discriminatory manner. So I kicked that juror off the panel to avoid him poisoning all the other jurors when it came time for deliberations. I always kick poisonous jurors off my juries. I had this trial where my client had been hurt, so I told the jury panel that we were asking for money damages during voir dire. I told them that the burden of proof in that case was just preponderance of the evidence, meaning more likely than not. That means that they only had to be 51% sure in order to award my client the hundreds of thousands of dollars that we were asking for. Then came the big question. How many of you think that you'd have to be more than 51% sure to award my client hundreds of thousands of dollars? A whole bunch of hands popped up. I went through each one and each of them had the same belief. They couldn't award hundreds of thousands of dollars if they were just 51% sure. That means that they were going to hold me to a higher burden of proof than the law requires, which means that they weren't willing to apply the law. When I asked the judge to strike them for cause, he insisted on speaking with them first to see if they could be rehabilitated. Bravely, they stuck to their guns and told the judge that they needed more evidence than the law requires. So we kicked every single one of them off the jury. I always kick jurors who won't follow the law off my juries. Each strike, 2 for cause and 1 peremptory, served the same purpose. ensuring a level playing field. Jurors are always going to bring their experiences into the courtroom, and that diversity is a strength. But impartiality suffers when their biases and beliefs outweigh their duty to follow the evidence and the law. Strikes for cause and peremptory challenges are the tools that we use to remove that risk before it enters the deliberation room. Some people think that these tools are just a means for manipulating a panel until only friendly jurors remain. In reality, they are tightly regulated. But I'm sure you already know how jury selection actually works and how you aren't picked to serve. Just like I'm sure you already know about that dirty phrase that you're not allowed to talk about during jury selection. No? Well, click one. Go ahead. Don't wait for the video to stop. Just click one now.